now we are going to turn to our keynote speaker for today, Lothar Ehring. Lothar Ehring is working at the DG Trade of the European Commission and was one of the main co-authors of the anti-coercion instrument. The floor is yours. Would you rather das oder?
Thank you very much. Good afternoon. And thank you especially to the organizers, Dr. Böttner, Ms. Kirchhoff, Professor Tietje, for inviting me and giving me the honor to speak before you as a keynote speaker. I can admit that I think that is the first time I am giving a keynote speech. But it's not the first keynote speech I have heard, and it's not the first keynote speech that you have heard, I'm sure. And if you think back, if we together think back about keynote speeches that we have heard in the past, I can think of 2 or 3 different types of keynote speeches. The most frequent, perhaps, is the conference dinner keynote speaker before dessert or the like. When you've had a meal, you're sitting at the comfortable dinner table with wine and water, or more formally in a conference setting. What I mean is not the form but the content, and the keynote speech, which is nice and thoughtful but hardly interesting, because you don't learn anything in it, from it, that you don't already know. It is a textbook, conventional wisdom being recalled and nicely ordered chronologically or otherwise. At least I have heard several keynote speeches like that. Another type of keynote speech is the one that you remember forever, because it opened your eyes to something new or allowed you to understand something that you haven't so far understood, or one which, as the first type certainly doesn't do, makes a real contribution to the scholarly discipline in question, which normally every academic activity should achieve, no? Every conference paper, every conference presentation, every publication. Okay, maybe not every lecture in the auditorium before undergraduate students, but you understand what I mean. A recent very nice example, to which I will refer again later, in my view has very recently been presented at the annual meeting of the American Society of International Law, which you all know, even if perhaps you have not or not all been to those gatherings. And if so, that's not a problem, because it's all available online, as is the speech or keynote speech. Actually, they have several flagship speeches, and one, perhaps the preeminent one, is called the Hugo Grotius lecture, with which the conference is opened every year. And this year, in April, Professor Philip Sands from London gave that speech. If you don't know that speech yet, I recommend it to you very warmly. A very powerful speech about the state and future, possible future, of international law. Now, this year being my first attempt, I don't aim to fall into that second category. That would be overly ambitious. But I will do everything I can to not fall in the former category, because that would be a waste of your time and it would be a waste of my time. And we don't have time to waste, certainly not in international law, also not in economic security, whatever it is that we hold close to our heart. The title for me, I think, is the second part of the title of your conference, External Trade and Economic Security. That's how I will use it for myself. In passing, I cannot resist mentioning that your conference title has very stark tension in that one-liner, because it is EU foreign and security policy. I think that can only be the common foreign and security policy. The C word is missing, but FSP does not exist otherwise in EU law than in the CFSP. And trade policy, or the common commercial policy as it is called in the Treaty on the Functioning of the European Union, is not part of the common foreign and security policy. Both are part, jointly, along with other areas like development policy, of what in EU law, under the EU treaties, is called external action of the European Union. The term foreign policy is an informal term which journalists, of course, use. I see it being used also in administration, in practice, but this is not, as far as I know, not an official formal term that exists in statutory texts. External action is that term, and there are these different parts. The CFSP is regulated in the Treaty on European Union. The other external actions are regulated in the Treaty on the Functioning of the European Union. And myself, being active only in that part of the external action of the European Union, common commercial policy, I will focus on this, bearing in mind, however, what is ultra important and known to everybody like you, that of course the different external actions of the European Union all have to be applied and pursued consistently with another, and the objectives which are listed at the beginning of the Treaty on European Union are part and parcel of any external action, and therefore also of the common commercial policy. Although that's not necessary, but Articles 205, the first article in the part of the Treaty on the Functioning of the European Union on external action, recalls this, and again the last sentence in the first paragraph of Article 207, which is the common commercial policy, recalls that as well. So we can, of course, anchor all these things together and make sure that they are understood and applied consistently with another. In no area other than especially this term and wording of economic security is this as important as here. Let me also ask you very directly, but what is economic security? I was introduced as an official from the Directorate-General for Trade of the European Commission. For a year and a few months, the Directorate-General has a new name, which is Trade and Economic Security. So, as a service, a part of the European Commission, there is a valid question, a valid need of knowing what this actually means. You cannot have words in the title of your organization without a sufficiently clear understanding of what these terms mean. And believe it or not, that definition has still not been provided. These terms also more broadly outside the European Union, because obviously we're speaking about international trade policy, trade and investment, something much broader than just European Union. The whole world is a participant, and therefore this definitional question is one not owned by the European Union. But also outside the European Union, in scholarship, you find many attempts or many uses of this terminology, but I think a clear and precise understanding is still lacking. We also all know and understand immediately that had you asked 10 years ago what economic security means, you would have received a very different answer than today. At the time, possibly, you would have been referred to things like fighting poverty, guaranteeing income, housing. Definitions like that exist in the International Labour Organization, but that is, of course, not at all what we are talking about. Still, I think it's good to recall, you probably, like me, learned at school that definitions are neither wrong nor correct. They can be useful or not useful. But that is true for scientific definitions. You have a concept like time or distance, I don't know, and then you define it and you say this is what it is, and then that is what it is. Either that's useful in the reality or is not. In law, I don't think this rule applies when terms exist in some statutory language, because this is something you learned after school when you studied law, that legal terms, when they are not defined in the legislation, will be defined through interpretation. And that is something that has to be done correctly. So in this realm, correct and incorrect definitions do exist. But you are a little bit between the two when a term is to be defined authoritatively, not in a judgment, which has to follow the rules on interpretation, but in legislation itself. If you craft legislation, you are free to define in that statute. And then it is not about correct or wrong, it is about whatever you have defined it in. I think that for economic security, which is not a term in any international trade or investment treaty, at least not yet, I think we are somewhere in the middle between the two. It is about definitional freedom, yes, there's a lot of that, but I think it also is a question of making sense and like in legal definition when we interpret, being sufficiently rooted and premised in the wording and their meaning, their ordinary meaning, context, object, and purpose. If we do that, then I think we would be much closer to how economic security was understood like 10 years ago than the way it is today. Because if you just take the term economic, what does economic mean? Yeah, economic is the adjective of economy. What is the economy? Now, I'm not an economist, but my faint recollection is that the economy is the human activity about the production, distribution, consumption of goods, services, and capital assets. And then economic security. What does security mean? That's also a term we know. We have to be a little bit careful because there are languages in which security and safety are the same word, and then some where it's not. Some languages even have 3 different words, but they overlap. Yet security very clearly means, doesn't it, protection against harm. So if you put this security and this adjective economic together, then I think you are in a definition which would be guaranteeing. Obviously, we're speaking about state functions, the public law meaning, or public international law meaning. So governmental activities that aim to safeguard the ability of the economy to continue to provide for the goods and the services which humans need for survival, welfare, health, and so on. That's how I would define it, you know, and not only because I am insisting on terminology. I think these are important functions. A government is there for its people, for the residents of its territory, which may be citizens and non-citizens, plus the citizens that are abroad. Those are the human beings for which a government is primarily responsible for, and it has also, under human rights, positive obligations to protect, to provide for these human beings. And it would be a very important function of a government to make sure that there is no famine, there is no shortage in essential medicines, there is no shortage in clean water. And you know how important all these things are in very core parts of international law, international humanitarian law, for example, but also international human rights law, and certainly international economic law. And the regulation of international trade and investment has a part to play here. That's why I think this would be quite a useful understanding and definition. But, you know, to not lead you too much further into a direction which is not the one that you are working on according to the program of this conference, maybe also not the one that you are most interested in, I will now make a radical shift and turn to the understanding of economic security as we experience it around it, as we practice it, some of us, and how you analyze, describe, but perhaps also more than that, prescribe and recommend it. And then, of course, we get into something that is related to the subjects of your conference, but we can also trace it back to a hard realization that years ago we thought that economic interdependence between different nations is one of the best ways to secure peace and economic prosperity simultaneously, competitiveness and all the rest. But then we realized how precisely the trade and the networks that connected us into interdependent economies, the energy pipelines, the vaccine production, the medicines, or microchip productions in concentrated locations only, or shipping lanes for that matter, to take a very recent example, that these were exactly no longer part of the protective shield, but being used as weapons willfully, or even where that did not happen, that these were the sources or promoters or accelerators of exogenous shocks based on natural disasters maybe, or a pandemic, or other disruptions, perhaps secondary spillover effects of armed conflict. And that is why today, in practice, economic security is understood inter alia as a bundle of policy interests that are being pursued in order to reduce this type of harm, to reduce dependencies and the ability of others to weaponize trade. So depending on which way you go, the subject I was introduced with, coercion, anti-coercion, either has something to do with economic security or has nothing to do with economic security. In my notion, it has nothing to do with economic security. If a US president threatens to impose import duties against European EU and non-EU countries their exports to the United States because those countries are cooperating with Denmark for the protection of Danish sovereignty over Greenland, then, yeah, there is a trade measure, so we have something economic, but it is not those import duties on European exports that are a threat to those core vital interests that I've mentioned. They are a threat to some portion of economic prosperity, export income. Every dollar matters, of course, for GDP, turnover of companies, profits, the income taxes, they contribute to the treasury for public policies. But it is not the real core of those economic security interests that are affected. Whereas in the other understanding, yeah, probably one can fit also the anti-coercion instrument in that, and for that reason, and because I can say a few things about it, I will return to the anti-coercion instrument later. There are also other recent examples, of course, that you all know. Legislation that already exists and is being reformed, or recently adopted new legislation, or proposed new legislation not yet adopted but already formally proposed by the European Commission in the European Union for either reforming existing legislation or creating new legislation. So those, and I will not distinguish now each time, and I will also not go into details on each of these policies, but rather mention them and then try to extract insights together with you from this and other things, because otherwise I risk boring you and myself with a descriptive, I'll mention the first one, foreign direct investment screening, our outward investment screening. The one exists, is recent at the EU level, the other one is probably future. We would stay, if I presented you content on these, we would really stay at the surface. Of course, one can go into details and then find analytically or scholarly interesting aspects, but not on all of those, in the minutes that remain. And I would fear that, also I would have to hope that you fall asleep of boredom before I fall myself asleep of boredom, because the latter would be far more embarrassing. So we have FDI screening, we have outward investment screening, we have export controls. That's of course also economic security, isn't it? Because yeah, it is economic, it is also security, because export controls aim to prevent others from building better, more effective weapons and possibly one day using them against you. If these are destination countries you don't trust sufficiently, that are not allies, then you are entitled under all trade agreements, including even the EU treaty. I hope you know or remember that the European Court of Justice early on made rulings also about the internal market, the exception in Article 36 on the free movement of goods, that this international security, in the sense between member states, is part of the term public security in Article 36. And this meant and means that member states are entitled to, or where, yeah, it's a little bit historic, so I don't know the latest in this respect. I mention it also because by today's standards and the degree of cooperation and also trust between member states, it's more difficult to imagine. But at the time, the ruling, black on white, meant that member states can impose these measures also against each other. All the more externally, that is then a question of competence. You may know that the European Union dual-use regulation is fairly recent. I think the first version is from the late 80s or something like that. So for decades, there was no EU-level legislation, but there was the free movement of goods internally, with the exception I mentioned, and there was the common commercial policy, which at the end of the transition period, so since 1970, I guess, was an exclusive competence, meaning also, which member states at the time would never have accepted. I don't know whether we are there today, but I can tell you that this is certainly our view and my view. I mention in passing that I speak here only in my personal capacity, not on behalf of the European Commission, but it's not excluded that I occasionally say things that are the official position of the Commission or of the collective of colleagues and myself who work in this area. And so our position would always have been that regulating dual-use exports is regulating exports, and regulating exports is regulating trade. And therefore, that is common commercial policy and exclusive policy. And member states have transferred entirely that policy to the European Union. So how come that in the absence of EU foreign trade legislation in this area, member states did and could continue to be active in this field? Again, we speak of exceptions because there are two regulations, the original versions of which date back to 1969 and 1970. They were, one was adopted last minute before the entry into force of the exclusivity. The other one, I think, weeks after, on imports and exports. And both had an exception, which was the Article 36, the internal free movement of goods exception, copied word by word as an exception from the prohibition which these regulations repeat on so-called quantitative restrictions, which probably means non-tariff restrictions, border restrictions, as we say in international trade law, on imports and exports, or even better, in GATT parlance, on importation and exportation. And dual-use export restrictions are, of course, such border, non-tariff restrictions on exportation. These exceptions, at the time, I have not been able to trace this historically, unfortunately. I would wish to one day still do that or be able to do that. It's difficult to find witnesses that are still alive and were involved at that period. It's a little bit too long ago to still find that today, in order to find out what did people actually think at the time. I'm not even sure the concept of exclusive competence was known and understood at the level of EU law at the time, because that, I think the first rulings are from the early 70s, fishery policies, and that was the UK Accession Act. And the common commercial policy as exclusive competence is what matters here for us, not fisheries policy. So did people, the drafters, the council, which adopted these regulations at the time as a legislator, did it have the intention to what we today call empower, which is return, the competence to the member states, which they otherwise would not have? Well, certainly these exceptions don't read that way. They don't say are hereby empowered. they also don't even read like constitutive legal provisions. They rather read like declaratory provisions, because they start, if I recall correctly, on words like nothing in this regulation prevents member states from. Yeah. Well, but we know that also in international treatments, language of nothing prevents is used for exceptions, does not necessarily always recall a right which must exist and has its source elsewhere. But the problem is that nothing in this regulation prevents. That gets you back to Article 1 of these regulations, where a prohibition on quantitative restrictions is codified. But even if you lift this one, you still have the competence barrier. But anyway, the Court of Justice has understood, and we today do understand these exceptions as empowerments of allowing member states to take action on the basis of these exceptions, with everything that comes with it. Not generous wide interpretation, burden of proof, and so on. There was a time when, with my doubts, trying to find out what was actually the historic origin, did the legislator at the time have a misunderstanding, thinking that this right exists already somewhere in the treaty and is merely being recalled. But the fact of the matter is that exception did not and does not exist in the treaty. The most related ones are, as I already mentioned, 36 on internal market, and then at the back end of the Treaty on the Functioning of the European Union, we have two exceptions, 346 and 347, which are what we call security exceptions. But they also don't cover this. Why not? Because 346 is narrower than the dual-use control permitting exception in the WTO agreement. It only applies to weapons. Does not apply to other goods. And 347 is a narrow security exception of the last subtype in the WTO, also with narrower scope, because it does not apply in all situations of war or other emergency in international relations, but only in situations of war or serious, grave tensions amounting to a threat of war. That's a higher threshold. In any way, one that is completely unusable for export controls, which are peacetime, permanent measures that you don't apply only in crisis situations vis-à-vis those few countries, hopefully, with which you are in a international relations crisis, whatever the threshold should be. It was these exceptions which I was sometimes wondering, why are they there? Are they actually needed? Should one not ideally remove them? Because there's no justification for them. I have completely changed my view on this between us, but that's just my personal opinion as well as experience. And I believe that these exceptions are core, important, in order to allow member states to take action when they have to, and when they're not doing so, may well result in a breach of their, as member states, human rights obligations under their national constitutions, under their international human rights law obligations, and perhaps even EU-level positive obligations to protect human rights. Think back of the pandemic, face masks, not yet being restricted at EU level, but being scarce and being needed, and in the absence of which causing more deaths. Yeah? Health workers at the time, in the early weeks of the pandemic. A member state must be able in such a situation to restrict trade. We don't have to now go into details of EU internal trade as much as EU external trade. For these exceptions, we're speaking only about the external trade part, and the other one is then internal market, Article 36, where that exception exists in the same wording. Member states must be able to have that capability. If they don't have it, because they have handed over fully the competence for that regulation of international economic relations to the EU level, then I fear a clash, constitutional clash, and you know from the well-known theories and different opinions and so on, how that clash is resolved when push comes to shove. At the end of the day, it is the member states' obligations under their constitutions that will be the stronger ones. So these exceptions give the space that is needed as soon as the EU level takes action which is sufficient to protect life and health. Let's say that justification for member state action falls away, and we are all happy again. The exclusive competence is re-established, or recourse to that exception is no longer possible. But that's not the situation I have in mind. Okay, so I mentioned export controls. We went into quite a bit of detail, going well beyond dual use. There is, of course, also weapons trade, real weapons trade. There we have Article 346, of course. But those, when I studied, I still remember that these exceptions at the back end of the, at the time, EEC treaty, then EC treaty, were understood, at least by many member states, as carve-outs from the scope of application of the EU treaties. But that is now already overtaken by developments, jurisprudence. They are exceptions, and they have to be invoked in individual situations. These are not areas in which the rest of the treaty does not apply. On the contrary, weapons trade is trade, and the exportation or even cross-border movement of weapons is trade. When a nuclear submarine is being sold to another country, that is trade. But also without sale, that is trade. Just like a ship or a truck that crosses border with or without merchandise is international trade, because the truck is a good and the ship is a good. And the same is true for weapons of whatever form. So this falls under the common commercial policy. Is not the area in which now the focus lies for economic security, and therefore I will not go more deeply into it. But there's one more thing I want to mention in this context, which is another variable in this equation, which is a little bit difficult to manage, and that's the last sentence of Article 4, Paragraph 2 of the Treaty on European Union. The sentence which says roughly that the national security is the sole responsibility of the member states. Well, you understand very well, one doesn't even have to be a lawyer, what sole responsibility means, right? It means that the European Union has no responsibility in this area. So this is a negative EU competence attribution. But what does national security mean? It cannot mean the same national security which is often an exception in a trade agreement. In fact, very often it does not say national security, but rather essential security. But national security, even in the WTO agreement, does pop up in various places. Whether that means anything different from essential security is far less certain. But I also do remember statements like the EU cannot invoke these provisions on national security because the European Union does not have a national security. To begin with, the European Union is not a nation. It is not a nation state, yeah? But again, here we come to that meaning of definitions I mentioned earlier. These are treaty terms. They are not defined in this statute or in other statutes. Of inferior level, that would also not be possible legally. And therefore, we have to interpret these words and find out what exactly they mean. Yeah? And so far, so good. I have not seen Article 4.2, last sentence, being used as a shield, as a barrier, and therefore I won't go further into it. But it is, of course, a important part of EU law, of common foreign security policy, I guess. National security does cover things that we know well, but this can also be very broad. But it certainly covers things like counter-espionage, yes, and certainly territorial integrity, military. Yeah, there we are certainly in hardcore member state competences. Moving back to more traditional trade areas, the disruptions and experiences of the last years, and now the growing concern with dependencies and possible weaponization has given rise to legislation of a type that didn't exist beforehand on supply chain resilience, raw materials, other resources, medicines, Critical Medicines Act, and these fall into that category, of both categories actually, of economic security. There is also the prevention of possible harm through interference that is technically possible through goods, which traditionally goods presented a threat in the importing country only from their physical characteristics. If a good was toxic or hazardous, yeah, that was a security or safety rather risk in the country of destination, whereas other things, labor conditions, environmental degradation, they stayed in the country of production. But at importation, it was enough to inspect a product, think of medicines, you look exactly what is the composition, is this healthy, is this dangerous, risky, and on that basis you either authorize the sale or not, and you typically do that on a completely non-discriminatory horizontal basis because origin does not matter, composition matters, whatever the origin. And now we have this growing number of products where the link to the factory abroad where the good was manufactured is not severed at the moment or even before importation when the good is put on a ship in the country of origin, but the product remains connected with somebody in the country of production or elsewhere who continues to have an ability to affect the functioning and even the need through software updates, maintenance done remotely, and the like. And these concerns today are mostly geographically related to towards the east, Russia, China. But I think it's very important that we keep in mind that these are objective factors, objective risks that don't necessarily have only one origin. Sabotage, terrorism can originate on your own domestic territory. And that is why it is completely reasonable to demand, and it is also an obligation of governmental authorities, to ensure that products are not safety and security hazards, because they can be turned into weapons, they can be paralyzed en masse. Think of inverters in electrical grids, where you don't even need to control the grid and inverters as a whole. It is enough to be able to destabilize the network by affecting just a small, very small portion of these products, and the whole network breaks down. So it is only legitimate and necessary to allow governments to take action there. We have to look at existing rules, existing exceptions in trade agreements with these new questions and new types of facts, which in the past could only have been imagined, and in the meantime we have gained practical experience, or at least we know more such cases of application. And we have to soundly interpret the rules that exist to these new circumstances. That's what you always do with existing legislation and new facts that arise. And it is only after doing this properly and well enough that you can at all answer the question whether new rules are needed, whether additional exceptions are needed. Many have jumped too quickly to the conclusion that there is a need for more exceptions, that there needs to be an exception to protect critical infrastructure, for example. Yes. Why do I say that? I'm not yet convinced by the need for such new exceptions. That's because, not because we can liberally invoke the security exception of trade agreements. As you know, there's only one country in the world, one member of the WTO, who believes that this exception is self-judging and non-justiciable. There used to be a couple more. Saudi Arabia, for example, the Russian Federation, and to their credit, one can say that these have given up that opinion and position and replaced it by 180 degrees the opposite position, which is the correct one, the only defendable one for the reasons you probably know well. There cannot be in an obligatory international treaty an exception that is self-judging and therefore renders all obligations in that treaty to which this exception applies equally non-binding, as this exception would be self-judging. And we already spoke a bit about parts of that exception. It just doesn't apply to what I just mentioned, except if you do two things. One would be to think that the purchase and use of these infrastructures to some extent is also used by your own armed forces, right? If you have a telecommunications network and you don't want 5G to be vulnerable to interference, then you could try to make the argument that the armed forces also use mobile communication networks. I'm not an expert in this area, but a priori I don't find that overly credible because, first of all, it is only very partial use, and the exception then would only be able to cover that small marginal partial use, but also because, as far as I understand, those armed forces, they have their own completely autonomous systems of communication. And so it's not that they won't be able to communicate with another anymore because the mobile network breaks down. And the other thing you can try is, some have done that a little bit in the literature, which, by the way, is completely behind the curve. Yes, I know whom I'm talking to. You are all young scholars. You are the future generation of scholars and academics in these areas. You have your own personal research interests, and that's only legitimate that you choose them as you like. But I can tell you that there is also a utility that you can respond to, and a need, namely to answer those questions that pose themselves for a number of years already. The 5G saga with Huawei being excluded from now on, this is not yesterday, you know? This is at least a 10-year-old story. And now try to find good scholarly analysis on the question of how to justify the exclusion of telecommunication networks products from one member state, and on what basis. It's completely underexposed. So that's why in the little that there is so far, and you could find, is that idea that the use and abuse of those products could then qualify as the use of implements of war in the situation of war. But again, that is, I think, not overly credible for peacetime use, which we are after. To slowly come to an end of my part, I want to not omit to say a few words about the anti-coercion instrument. I will not go into details of what coercion means, but you probably know that this has its source in customary international law, which is particularly challenging because by definition it is unwritten, so you don't have texts. There's very little by way of confirmation, no ILC draft articles in this area, but the ILC last year announced that it wants to work in, more broadly, the question of non-intervention. It's a very wide field, as you know, with many sub-elements, only one of which is coercion. But this non-intervention principle, the prohibition of interference in the reserved domain of other states, or also of the European Union, who we believe must have the same protection where it has been given and exercises competence. That is the premise, the international law breach, which allows the taking of countermeasures in response where needed. That is more traditional and better codified, customary international law, with interesting aspects, of course, because many, if not most, of these countermeasures would need a justification because they depart from international trade agreement obligations, and that gets us into a very interesting field, which we will not resolve today, of whether that is possible, because we are not speaking about an exception, a written exception inside the WTO treaty, but an unwritten exception in customary international law, and therefore outside the WTO agreement. So there are these very interesting questions of general international law, of interaction between different parts of international law, regime interaction. Maybe you remember that term. I was told recently that 20 years ago, regime interaction was a very hot topic. I believe that regime interaction is an even hotter topic today. Why so? And these are the last thoughts I want to share with you on this wider question. That is because I think there is a new frontier that we are yet to explore much better, and that is the interaction between international economic law, trade law, and human rights obligations. I alluded to several aspects of this already, but what I haven't yet mentioned is another underexposed question, namely to what extent the imposition of trade restricting measures like import tariffs, which are an indirect tax, just like a domestic internal indirect tax, with the only exception that it applies only to goods that are imported and not to all goods sold in the territory. The imposition of such a payment obligation on citizens, not all of which are foreigners, by the way, or foreign residents, because the importer is often a domestic resident. That imposition of a public law payment obligation must be understood as a limitation of fundamental rights or freedoms. But so far, nobody has made it to that very, in my view, trivial realization. One must also admit that doctrinally, this is a bit tricky, because in every regime, this is a little bit different. For the Germans amongst us, I think that the jurisprudence or scholarship distinguishes between direct taxes, indirect taxes. The former are protected by a property guarantee. The latter are not, but this doesn't really matter in Germany, because there is always a horizontal residual fundamental right which does cover also the latter, and non-discrimination, equal treatment applies supposedly also in this area. You may know that in international human rights catalogs, things are importantly different in that zone. Yeah? Not when it comes to the protection of life and health, but precisely here. But that is why property protection may be a bit wider in these also European ECHR contexts, or European. There are some differences, but there's just not enough practice and no body of conventional wisdom and accepted steps of verification for the constitutionality or legality of such restrictions, because trade policy measures inevitably, unless they are subsidies, yeah, which can also be a trade policy measure, and by the way, one which in these areas of economic security we should not discount. There is a very clear hierarchy of preference in trade agreements on different forms of governmental intervention, where the subsidy stands very high at the top. Then comes the tariff, the permitted tariff, then comes the internal discrimination, and we are already in the red zone, and at the very end comes the intransparent gray area trade restriction. So before governments resort to the latter type and rely on an exception, which theoretically is possible, at least when we deal with the protection. I mentioned infrastructure before and didn't finish that thought. When we do deal with infrastructure that is essential for safeguarding survival and health, or prevention of health harm, yeah? Water, energy, food, essential medicines. Microchips, I'm less sure. Yes? Minerals, less sure. Cars, even less sure. It's not because ambulances are important for protecting health and life that you can say, or we can resort to the health exception for restriction in this area. So before taking discriminatory measures, at least governments which can afford that should, for reasons of good policy, because the subsidy is more efficient, cheaper for everybody economy-wide, and much more legal under international trade agreements. So subsidies are not limitations on property freedom or equality. Well, equality possibly, but not property and freedom, but the imposition of payment obligations are. And so this is something which I hope future research, but also practice if the cases come. Sometimes you have to wait for ages, decades, for obvious legal challenges that almost impose themselves to finally arrive in some courtroom, that we will then learn more and understand these areas better. Like in the last years, we have made enormous progress in understanding better, for example, the security exception. In closing, I want to say and show with the examples I have given, you know that some people say that international law is eroding, yes? I can't observe that yet at all. I think international law is still thriving, is still blooming and covering with a better understanding more and more areas. The problem is in enforcement. It is not in the existence and authority. And we should not too quickly speak of a crisis of international law, just like criminal lawyers would not convene for a conference and speak about the crisis of criminal law just because there is a flurry of bank robberies, yeah, or ATMs robberies, which has been a fashion a while ago. And this is exactly what Philip Sands said in his lecture recently, being as bold as to predict that the United States will come back to international law because it will realize that it is not half as powerful as it believes it is. He gave the example of the Iran war and explained very nicely in April who was on the back foot, whether it was Iran or whether it is the United States. So far he has been right, and let's see if he will be right more broadly. The future will tell. That we don't know for sure, but what we do know and can decide for ourselves is on which side of this effort we want to stand, in which direction we want to work, whether it is the participation in the dismantling of international law and reordering into something completely different just because the United States, inter alia, is not there as it has been over the last decades, or whether it is a call for resilience and upholding what we believe has worked well and we can make work even better in the future. Thank you very much.